I thank you all for coming today, and we have some people in person, and we also have, it looks like, almost 100 people on Zoom. So hello, Zoomers. Thank you for joining us. I also want to thank Paula Heider and Brian Fernbaugh for their help in putting this together. Also, to let you know, we should have some time for questions at the end. So even if you're on Zoom, when we get to the time for questions, if you raise your hand, we'll be able to raise your Zoom hand. We'll be able to call on you if you have a question, and we'll be able to hear you in the room. Also, if you are here for your one free CLE credit, have no fear. You will be getting information from the law school about how to claim your credit. So as a young immigration law associate in Philadelphia in the early 2000s, I knew of Steve Morley as one of the best immigration lawyers in town. And we didn't practice together, but his reputation was well known. And since then, Steve Morley became Judge Morley and similarly built an excellent reputation as an immigration judge in the Philadelphia Immigration Court. And after serving as an immigration judge for 12 years, Judge Morley retired in 2022. And we can learn a lot from Judge Morley about immigration law, as he is one of the nation's most prominent experts. But also his experiences with immigration law force us to confront some hard truths about the principles we say are at the core of our system of justice, but do not always reflect reality. In immigration court, immigration judges decide deportation cases with the power to divide even nuclear families and even to separate US citizen children and spouses from a loved one. Yet immigration judges are not Article 3 judges. Instead, they report to the Attorney General, who has control over the conditions of their employment. This leaves room for political control over immigration judges. Are we comfortable with that? Is that necessary? If so, should there be limits on political control over immigration judges? What does the experience of immigration judges tell us about agency adjudication generally? So I don't have to answer any of those questions today, but I can't think of anyone better to lead us in this discussion. So please join me in welcoming Judge Morley.
Well, thank you, Dean Hussey. Thank you, Professor Family. It is a pleasure to be here. You all applauded. I haven't said anything yet. I want to sort of spend a few minutes going over sort of the basics of immigration court. For some people here or on Zoom, this may be very elemental, but I think it's useful to just sort of talk about the immigration court system and understand what it is. So first of all, we're talking about the Executive Office for Immigration Review, commonly known as EOIR or EOIR, which has another meaning. It is an agency embedded in the Department of Justice. And if you think about the Department of Justice having about 110,000 employees, and we think mostly about the Department of Justice in terms of its criminal prosecutions and its civil enforcement, we have this small, maybe 5,000 employee division within the Department of Justice. It has basically three different parts within EOIR. The first is the Office of the Chief Immigration Judge, and that office oversees the immigration courts, of which there are now over 70. When I started, I think we were 58 or 59. They've now expanded and keep opening new courts. I don't know how many there are, but I'm sure you can get that information. I believe it's over 70. And those are the trial level immigration judges and their support staff. From that is the Board of Immigration Appeals, which currently has, I believe, 23 members. They changed their name now to appellate immigration judges. They used to be called board members. I'm still having a little trouble, getting the correct lingo because of so many years with calling them board members. And then there's the Office of the Chief Administrative Hearing Officer. That really hears mostly employer sanctions cases. And I only mention that, and then that's going to be it. I'm not going to talk anymore about OKO because it really is not relevant to our discussion of what is today. I'll give you a small sampling of the crush of work that has ballooned over the last few years within the immigration court. And that is when I joined the immigration court about 13 years ago in 2010, I was the fourth judge. They had three, they added four. At one previous time, they had four. Back up to four, 5,000 cases. We worked hard, but we were not overstressed. In other words, about 1,200 cases per judge, plus or minus. We had total staff, including a law clerk, a single law clerk for 4 judges, of 10 people. We had, and including a court administrator, and we had, so we had 4 judges, and we had 5,000 cases, 4 judges, 10 personnel. When I left in 2022, about 15 months ago, in the summer of 2022, we had 7 judges. We had about 22, 23 employees with 42,500 cases. So an increase of over 8 times in cases and about a doubling or a little bit more, a little less than doubling of number of judges, a little more than doubling of staff. That is why the immigration courts are in such a mess, or one of the reasons they're such a mess. So immigration judges are appointed by the Attorney General. I have a wonderful scroll framed certificate from Eric Holder, Attorney General, appointing me. And they are authorized by statute. We are mentioned in a statute, 240A and B, as well as in regulations. The Board of Immigration Appeals is purely a creature of regulation. There is no statutory authorization. So what do immigration judges do? We administer oaths to witnesses, we receive evidence, we can issue subpoenas, administrative subpoenas, we render decisions. That's kind of what you would expect a court sitting without a jury to do. What kinds of hearings? Most commonly, people think about deportation. In 1996 Act, they took what had been called exclusion proceedings, which were people who were not yet entered the United States officially or legally or had legal status as they came to the border. And those were people that were put in what's called exclusion proceedings. And then they had deportation proceedings, people who were already in the United States, and they were different sets of proceedings. And Congress decided to kind of make one set of proceedings that applied to all of it. And they called them removal proceedings. So they're in the statute, and they outline the basic framework of these proceedings, including what commences those proceedings, which is a charging document, similar that you might see in a civil case where you file a complaint, or in a criminal case that might be initiated by complaint or information or indictment. It's called a notice to appear. And that is issued or sent to either by mail or handed to a foreign national, telling them they have to come to court, and here's why. There's something called rescission proceedings. Sometimes USCIS, which is a separate agency under the Department of Homeland Security, as opposed to the courts, which are under the Department of Justice. USCIS will sometimes look at somebody who's been issued permanent residence, a green card in the United States, and say, oops, we made a mistake. We're going to rescind that. They have 5 years in which to do that. And immigration judges can review that decision. If the person seeks review in court, immigration judges review those. There are also things called asylum-only proceedings and withholding-only proceedings. And those are very esoteric, having to do with people who have returned under an order of removal having been issued previously, or for certain other statuses that that they've already been determined to be removable from the United States, but the judge can determine whether they should be permitted to stay because their life might be in danger in their home country. And so we do asylum only, withholding only proceedings where the question of the legality of their presence in the United States has already been determined. The only question is, can they stay because of fear of persecution? We also preside over the relief that somebody asks for. In other words, somebody is found to be removable from the United States. They can't stay here, but maybe they can. They can get relief. You've all probably heard of asylum. That is one of three kinds of what I call humanitarian relief. One is asylum, somebody who's in fear of persecution on account of race, religion, nationality, political opinion, or membership in a particular social group. And that the grant of asylum is a direct road to permanent residence and ultimately, of course, to citizenship. There is something called withholding of removal, which has the same characteristics as asylum, that is, persecution on account of one or more of those five groups. However, there's a higher burden of proof. It does not provide a clear path to any kind of further status in the United States. That person can remain in the United States. That person can get work authorization. They can be employed, but it does not provide a direct path for further status, such as permanent residence, i.e. a green card, and ultimately citizenship. And finally, there's something called protection under the Convention Against Torture. And that was relatively new. I mean, I call it new because it only really became effective in 1999, which was after I'd been practicing for close to a quarter century at that point. So for me, that's relatively new. But protection under the Convention Against Torture is a little different than asylum and withholding. The burdens are different, and you don't have to link it to one of those five classes of protected grounds: race, religion, nationality, political opinion, membership in a particular social group. And that also does not provide a pathway to any further status in the United States. So those are the humanitarian relief hearings that judges do. They also sometimes do adjustment of status. That is, somebody who is, for example, there are a number of different ways one can adjust status to permanent residence. The most prevalent is marriage to a U.S. citizen. Somebody gets married to a U.S. citizen. They apply for their permanent residence. USCIS, which is the Department of Homeland Security's branch that grants status, finds there's a problem. That is then reviewed de novo. That is, the judges don't have to rely upon anything that USCIS did. We have an opportunity to look at the case anew and decide, should this person get a green card or not? In that context, sometimes we also adjudicate waivers, and waivers are exceptions. In other words, let's say somebody has a particular kind of criminal record. Certain types of people can be forgiven because of the relationships in their family. And so the judge would adjudicate that along with the application for permanent residence. We also do something called cancellation of removal for permanent residence and also non-lawful permanent residence. For permanent residence, it's like the second chance at life in America. Somebody has done something, somebody's a permanent resident. That means they're still a foreign national. They have a green card, but they can still be removed from the United States. They are not a citizen. So those people, if they are in our country, and usually it's a criminal problem, and if they qualify for certain kinds of crimes or not having committed certain kinds of crimes within certain time frames, they can come to an immigration court, and the judge will have found, yes, you are removable, or maybe they'll have conceded, yes, I'm removable, but please, judge, can I have a second chance at life in America? And that's what a cancellation of removal hearing for a permanent resident entails. You know, weighing the equities, you know, family versus and paying taxes and community involvement versus the nature and recency of any criminal contacts, as well as any other immigration violations. And it's balancing. It's within the discretion of the judge to decide. Does this person get another chance or not? Cancellation for non-lawful permanent residents. These are people who, by and large, do not have documentation. They have either overstayed their visa or have come across the border without permission, and they've stayed here for 10 years or more. They also have family members. They also have not committed crimes that make them removable, and they're also people of, quote, good moral character, and that's a statutory term that's defined. It's not just, hey, you're a good person. Statute about good moral. If they're able to establish those four elements, and the hardship standard is exceptional and extremely unusual hardship to U.S. citizen or permanent resident, spouse, parent, or child, and or spouse, parent, or child, then the judge has the authority to say, you can stay, and this is, you know, and this grant then becomes permanent residence, so it's a direct road to permanent residence and citizenship. So those are a lot. In fact, there's a period of time when I'd say that 40% of my caseload was cancellation of removal of non-lawful permanent residents, 40% was asylum cases and related humanitarian relief, and the other 20% was a hodgepodge of, you know, other, you know, adjustments and not cancellation for permanent residents and contested removal hearings, things like that. And then there's something called voluntary departure. Somebody facing removal from the United States can say, you know what? Give me a little bit of time. Maximum amount of time is 4 months. I'm ready to leave. And we can adjudicate whether they, in a discretionary basis, are allowed to do that. Judges also do, just quickly, bond determinations, determinations of credible fear. That is, somebody who comes across the border, they're interviewed by an asylum officer. The asylum officer says, you do not have a credible fear that you'll be persecuted upon return to your country. They say, well, I want a judge to look at this case. Fine. Judge looks at it. The judge either says, I agree with the asylum officer and out of the Department of Homeland Security, or says, I disagree. If he disagrees, the case then becomes a court case. Reasonable fear is the same kind of thing. It stems from somebody who's been deported once before coming back, and they get that same kind. And the standards of proof are a little bit different. And then judges also frequently do motions to reopen and reconsider past decisions. The jurisdiction and powers are set forth in regulation. The board of Immigration Appeals has discrete powers and jurisdiction. Most of what my involvement with the board has been, both as a practicing lawyer, as a judge, is they hear appeals. They hear appeals from judges. The appeals will be filed within 30 days. Either party may take an appeal. The board must defer to the immigration judge in terms of findings of fact and determinations of credibility, so long as they are not clearly erroneous. On the other hand, the board has de novo review, can review anew any question of law and any determination of discretion. So remember when I was telling you about I'm an immigration judge and I weigh and balance the discretion about whether or not to grant cancellation of removal, you know, and I add up the good or adjustment status, you know, the good and the bad in the person's background. And I said, well, there's more good here than outweighs the bad. The Board of Immigration Appeals can reverse that and say, no, we see more bad than good, or vice versa. You know, depends who takes the case. So let's talk a little bit about what it means when we say we have a court. We have a system of adjudication. So these are some ideas that I think tell us what it means to be a court. We have a system of adjudication based solely on evidence. We have a system of safeguards that are supposed to be devoid of outside influence. We have Alexander Hamilton in Federalist number 78. There is no liberty if the power of judging be not separated from the legislative and executive powers. And the reason for that, I think, is clear. It's not just we like that, it makes sense, but it's a way of ensuring the rule of law. So I'm going to give you a quick synopsis of what happened to me. And I'm going to use the first person here because I was, it was really kind of my involvement, and therefore, but I want to walk through what I call the Castro-Tum problem. I'll also talk about the Attorney General's ability to alter the immigration policy by taking cases and redeciding the law. And finally, the question of, is the immigration court an agency or a court? And if we say it's an agency, what does that mean in terms of how we structure the system? So immigration judges had, from time immemorial, or for at least 40 years, the ability to administratively close a case. That means take a case and put it on the shelf and let it collect dust. It was a tool that was basically a docket management tool. But it could only happen when both parties agreed. That changed in 2012 when the Board of Immigration Appeals said it's okay for one party to move to administratively close a case so long as they meet various factors. And the board set out factors in this case called matter of Edison. They followed up with another case, I think it was matter of WYU, I can't use them alphabets, but there was a subsequent decision that kind of clarified some things. So this was again, a heightened use of docket management, and it came at a time, starting in 2012, when the backlogs began to grow. Now, one of the factors that is not in the Edison or the subsequent decision is backlog. It's just not a factor. There are things that the judge is supposed to look at in a Edison, but not really the overall structure of the immigration court. That's fine. We would find that. What I found as a judge, and I handled, at that time, I was handling a lot of the juvenile docket as well as an adult caseload, is what disturbed me was whether or not juveniles were getting adequate notice of a hearing. And what bothered me was they would get a notice that was that I would get notice that the address, as the court would get notice, the address was derived from a one-page document from the Office of Refugee Resettlement from the Department of Health and Human Services that took custody of these minors as they crossed the border. And I looked at these documents and I said, how do I know the address on this page is really the correct address for the kid? How do I know who got that address, where it came from? There was no evidence. There was not a signature on that form from a government official. There was not the name of a government official on that form. It claimed it would say who the kid was being turned over to, what relative, and an address and phone number, but mistakes are frequently made, and I found them to be frequently made. And I just felt that the documentation as the source of the address to which such an important document was being mailed, that is the notice to appears that commences immigration court proceedings. And if somebody doesn't show up, they are ordered removed in their absence. Okay, there's an in absentia power of judges. In fact, it's required, if they've got proper notice, for the judge to order them removed in their absence. And I was concerned that the foundation of these addresses was not adequate. I had a bunch of these cases, and I sent them all up to the Board of Immigration Appeals, about 3 of them. The Department of Homeland Security was not happy. They kept saying, Judge, there's enough here for you to issue an in absentia order. And I said, I don't believe there is. Certainly not dealing with a minor. Unbeknownst to me, the Attorney General at that time Jeff Sessions, talked to one of these cases. And so what I did is I administratively closed the case. I could have said not adequate service, I am terminating. But I said to the government, I'll give you an opportunity. Get me better documents, get me better service, get me better documents, do something. I will not terminate this case yet. I'm going to give you a chance because I'm a fair judge. Sessions takes that case, one of those cases, Castro, and he says there is no such thing as administrative closure. It just knocks it out of the park, sends it back down and says, issue a hearing notice within 14 days. In fact, what I was directed to do, and the staff was directed to do, was issue a hearing, not a hearing notice within 14 days, but schedule a hearing in 14 days. That was over a holiday weekend, Memorial Day weekend. And I was concerned that there was simply and given the vagaries of mail service, I was concerned that this kid might not get service. And then I'd be back at square one again, should I continue it? And I also spotted kind of a legal issue that concerned me. Meanwhile, some members of the immigration bar in Philadelphia said they would act as amicus. So I said, fine, brief this legal question. And I said, my normal docket's out 6 months. Let's schedule this 2 months. 2 days later, court administrator has me looking at the computerized system of cases, and we note I'm no longer the assigned judge on Castro. And they've assigned it to the assistant chief immigration judge at the time. And not only that, they removed about 85 of my other cases of similar cases from my docket where I raised the question of, is this adequate notice? An assistant chief immigration judge from Falls Church, Virginia, came up to Philadelphia for the day, held a very brief hearing, and ordered Ronaldo Castro removed in absentia. The judges union, which is no longer a union, that's another story. But it's still a powerful association. Well, it's still an association. Well, it doesn't have the power it once had. We filed a grievance. EOIR issued a statement saying that I may have violated policies and procedures. The grievance denied. The grievance was denied, but they determined that I had not violated anything. And then there was a House Judiciary Subcommittee in 2021 on a bill to create an independent immigration court, what we call an Article 1 court. Now, immigration judges, because we're appointed by the Attorney General, we're never going to be Article 3 judge, that is appointed by the life tenure and all of that. But what we could be is an Article 1 court, Article 1 being created by Congress, a court that's actually created by Congress, and therefore more insulated from political power. So at this hearing, former IJ, who is now counsel or works at the Center for Migration Studies, said that when he was an immigration judge, he was an immigration judge down in York. He said nobody ever interfered with him. And Congresswoman Mary Gay Scanlon said, oh yeah, what happened in Philadelphia? So Castro Tom is an outlier. I am not, but for any moment saying that this routinely happens, that powers that be in the Department of Justice rip cases away, get orders of removal issued over objection of judges, but it is illustrative of the flaws in our system. And the current structure allows for the kind of problem that we've had, which is does not grant adequate respect for judicial independence. And it allows for a political agenda, or whether it's just a petty bureaucrat seeking to impress higher ups, to interfere with a particular case rather than let a judge independently decide, and if there's a wrong decision, that can be appealed. That's why we have appellate courts, appellate boards in this. So that's the Castro-Tongue problem, the ability to change the decision of a judge, to interfere with the decision of a judge. I, as the judge, wanted further briefing. That was called off, and an order of removal was just issued. The other problem, problem number two, is the Attorney General's referral and review ability to take a case, as he took Castro-Tongue, and rewrite immigration law, rewrite binding precedent immigration law, because immigration judges are required, they're bound to follow the precedent as set by the Attorney General. Indeed, the Board of Immigration Appeals has to follow the lead of decision-making of the Attorney General. So just an example of how often this gets used. In the last 20-some years, President George W. Bush used it 10 times within 8 years. President Barack Obama used the power to, his attorney generals used the power to reach down, grab a case, rewrite law 4 times in 8 years. And the Trump administration used this power 17 times in 4 years. They had an agenda, and they sought to maximize the use of this power of rewriting precedent. And as you can see, they did it quite aggressively. So if this ability of the Attorney General allows a political appointee to fashion immigration policy in terms of the political considerations. We all know that President Trump had a very clear political agenda when it came to immigration. We know the milieu out of which his first Attorney General arose and certainly followed with his second Attorney General, the same kind of attitude, and therefore allowed those individuals to rewrite law. Doesn't interfere with a specific case, but the decision binds all the immigration courts. Keep in mind, this is a single decision maker. It's not even a 3-judge panel that you might have in the federal court that would allow perhaps divergent ideas to come across. It permits the Attorney General to circumvent a rulemaking process. In other words, some of what binds immigration court are the regulations that are found, and I cited some of them, 1008 CFR 1003. Rulemaking requires notice and comment. As anemic as that sometimes is, it is at least something. But the Attorney General can just, out of whole cloth, rewrite policy. It allows the Attorney General to create policy without any input from Congress. What has happened, as you can see, was that in the ensuing years, so we had the Trump administration being very aggressive, saying immigration judges do not have the power to administratively close cases. Immigration judges do not have the power to terminate cases. Immigration judges shall not consider domestic violence to be a proper foundation for asylum. Those were all established law. The Trump administration kind of wiped the slate clean. What happens? We get the Biden administration. They vacate Castro-Tongue decision. Immigration judges can now go back and administratively close cases. Immigration judges can terminate cases. Immigration judges can follow the prior law that says that domestic violence is a basis for persecution in an asylum or withholding case. So this is this back and forth. It's no way to, while I might personally agree with the law as it stands now, and prior to the Trump administration, it is a poor way to run an immigration court, to have this ability to ping pong back and forth, and certainly contributes to backlog, because now we end up relitigating issues that we thought we'd resolved one way or the other. So remember, EOIR is a small, so the last question, is EOIR a court or an agency? We have about 5,000 employees, over 100,000 Police Department of Justice. At the Department of Justice, at the EOIR, there is a robust general counsel's office that addresses questions of law as well as regulations that impact the administration of justice. There's also an Office of Policy and Planning under the direct control of the director of the EOIR. Now, why do we have, I say we because I'm sort of in that mode of thinking of myself still as at the court, even though I'm not, but why do we have a general counsel's office with 20 attorneys advising on different aspects of immigration policy? Why is there an Office of Policy and Planning? So I'll give you an example, and you can actually look these up on the EOIR website, but I pulled one of them. In November of 2021, the director issued Policy Memo 22-03. That was in the wake of the Attorney General, the current Attorney General's decision to vacate Castro-Tum. And he did it in a case called Matter of Valdez Cruz. And so now immigration judges have the authority to administratively close cases. What our director, if you read between the lines, sees in this is the ability to help with the backlog, help with the volume. And so he issues a memo that basically says, judges, you should use this power broadly. And encourages using administrative closure basically as a way to solve his problem. He has to answer to people above him and to Congress, why are the immigration courts so backlogged? And if the judges will follow his policy memo and simply administratively close lots of cases, it gets to his administrative goals. It solves one of his administrative problems, which is an enormous backlog of cases. But backlog, as I mentioned before, is not a factor under matter of Vetzian and matter of WYU. That's not a consideration. So I remember reading that memo and being a little bit annoyed because at that point, 2021, I'd been a lawyer and a judge for a total of about 45 years. By that point, I think I knew how to read a case. I knew what to do with a case. And I didn't need the director of EOIR telling me what to do with it, you know, in terms of a policy memorandum that he's laying out. Let me give you another example of the problem for that's fine, which was under the Trump administration. There was set in place a system of, we called them quotas, they called them, the term they use, not guardrails, but anyway, you know, metrics. Basically, how many cases judges should complete. We're supposed to complete 700 cases a year, a number that nobody could quite figure out where it came from, but somebody's brain. And then a certain number of, and complete them within certain time frames. You know, a certain number had to be completed within 10 days after a merits hearing. A certain number had to be completed within 3 days after the initial merits hearing. I mean, it was like a very sort of complicated structure. The problem with these metrics is if you tell immigration judges, you have to complete 700 cases and you get credit for completing them. If, let's say, as a completed case is a closed case, you didn't get credit for administrative closure. That didn't help. So, you know, your incentive, even if you could administratively close cases, was not in that realm. But let's say you had a bunch of cases at a master calendar hearing where people didn't show up. Instead of scrutinizing very carefully whether or not they'd been properly noticed, whether the notice had properly been served for them to come to court on that day, you think in the back of your mind, if I issue an order of in absentia, that's a closed case. One more toward mine. Only $6.99 to go, right? And I think, that's an impingement on independence of the judiciary. If you tell judges you have to issue your decision within 10 days of a hearing, and it's a complicated case, and you want the law clerk to work on it with you, and the law clerk is really backed up, and you're dealing with, trying to get this decision out, and you're thinking you're not going to hold on to it for months and months, but you're thinking maybe 30 to 60 days would be a reasonable time to work on this decision and get the answer right. And meanwhile, you have the clock ticking. Oh crap, there's one that's not going to meet that metric. And I only have, it's like they have these little dials, there's green, you're in the green, you're in the orange, you're in the red. If you have too many cases in the red, your boss, the assistant chief immigration judge, is going to talk to you about this. Why are you getting so many cases out more than 10 days after the hearing? I figured out some workarounds, which I mentored younger judges on. But again, this is an administrative crunch on judicial independence. It tells a judge, go fast, not go right. And again, impinging on judicial independence. Those metrics were sort of withdrawn. They are no longer determinative, but they're still there. And judges are kind of like still watching them. Because I was older and, at the end, my career as a judge was sort of the capstone of my legal career as far as I was concerned. I personally wasn't bothered by it, but I know a lot of younger judges who are looking forward to, maybe decades more of practice of being a judge. This was a source of great stress to them. How do I meet my metrics, but meet my obligation to due process? And, it's hard enough to do the right thing. It's hard enough to resolve some of these cases and all the factors that you have to take into consideration, given the complexity of the law as written, as set down by the board, by the circuit courts. And all you now need is some bean counter in Falls Church looking at your dials. I did hear stories of I never had this experience. I always had very hands-off assistant chief immigration judges, which is the next level of supervisor. But I've heard stories in other parts of the country where they would send ACIJ, send a screenshot of the dials once a week saying, how you doing? This is how you're doing. Tell me why you're not doing it, and that's. So I don't think that there are sufficient guardrails. There's too much, there's the ability to interfere with individual cases and decisions. The Attorney General has way too much authority to shape immigration policy in consideration of political agenda. And the fact that the EOIR functions more as an agency and less as a court allows for unnecessary pressures to be put on judges, that those pressures interfere with judicial independence. I think the solution is an independent immigration court authorized under Article 1 of the Constitution. Last session, there was a bill. It never went anywhere, given the current political environment in Washington. Well, the House isn't considering anything, right? But I don't think it never had it never got to the Senate. It never really saw light of day. But I do think, this is the dream, the goal. And I think for people who are serious about what it means to be a court, to be a judge, to hold people's lives in your hand, this is the answer. One of my colleagues, who also retired, a judge out in California, always commented, being an immigration judge, I'll paraphrase, so I'm never great at quotes. Being an immigration judge is like doing death penalty cases in traffic court. And, it kind of is like that. I mean, there are stories, there are instances of judges making a decision to deny somebody asylum, and that person going back to their home country and being killed. So a lot is on the line. The court is woefully under-resourced. I remember talking to our court administrator, who's wonderful, and saying, "Are you getting new staff?" And she said, "Well, we got this one." I said, "This staff needs to double. You cannot do." As I said, 15 months ago, it was over 42,000 cases. You cannot do this volume of case without doubling the staff. Getting more judges is, only part of the solution. I also don't believe that there's an ability to litigate our way out of a $2.5 million case back. There needs to be something bigger at a structural level. But I think in terms of fairness and what it means to be a judge and to adjudicate cases in a meaningful way, we need to be freed from the strictures that I've got. So I think we have about 10 minutes left. I'll take any questions. Yeah.
So forgive me in advance, Your Honor. I probably have like so elementary view of how immigration court works. But let's see. So it sounds like the Attorney General then is like our Supreme Court. Like they determine all. Like, is it possible to override the Attorney General and go, let's say, straight to the SCOTUS? Or
no. So what happens? So the Board of Immigration Appeals really handles, I think they handle 30,000 cases a year. Every now and then, the Attorney General plucks a case because he or she wants to rewrite the precedent in a particular area. That then becomes binding on everybody down below. However, one can appeal a decision that maybe is in line with that to the circuit court, because that's the next avenue of appeal after the Board of Immigration Appeals is to the circuit court in the area in which you sit, in which case the Third Circuit's here. So what happened, for instance, with Castro Tom is that first the Fourth Circuit and then I believe the Seventh Circuit looked at what Attorney General Sessions had done in his rationale and said, no, that's wrong. And so they started allowing, so courts in those circuits started to permit immigration judges to administratively close cases. So that's sort of the process.
Any questions?
Yeah, in the back.
It seems that you were leaning towards the solution being creating a new system,
An Article 1 court, one that a court system that's created by Congress as opposed to one that is built into the Department of Justice. Get it out of the Department of Justice.
What's the feasibility you think of that?
You mean, what's the political reality of that happening? I am not optimistic. I think it's something to be hammered on. Maybe not I don't see it happening in the foreseeable future, perhaps down the road. But I don't know. I'm a lawyer and an ex-judge. I'm not much, and I have a passing interest in politics, but not one to plumb the depths of that in terms of reality. Greg.
Putting aside the politics of it, is there intellectual opposition, thoughtful opposition to keeping the courts in the Attorney General's office? Is there an argument in their favor?
I haven't heard one expressed. I think it's, the big one is financial. And then, one of the questions I had when the Biden administration came in, is why don't they get behind us? This is a great solution. And I think the answer is, turf. This is the Attorney General's turf, and nobody wanted to step on Merrick Garland's turf. And they weren't ready to make such a dramatic change. And that would have really required kind of a major overhaul. And I think at the end of the day, it might be more expensive. Or they perceived to be more expensive. But I haven't heard any intellectual basis to do it.
I haven't either, but I was just wondering, and just to follow up on the comment of what goes on after an attorney general opinion. If you have an attorney, you were present in court, you may be able to petition within 30 days for review. But what percentage of people that appear before the immigration court have attorneys? And if it's a nunc pro tunc,
Pro se.
a process, well, if it's a in absentia, my Latin. It's gonna be mixed up. If it's in
I took 2 years of Latin in high school. It doesn't do me any good.
how do you, how is that case, going to be appealed? Because
I mean, the only way, in absentia is, as what happens on an absentia is somebody gets picked up and deported, or somebody finds out about the in absentia, or while they're waiting to be deported, gets a lawyer who files a motion to reopen the case, arguing inadequate notice or whatever basis they can. So that does happen, but there were, there are a lot of people who have, outstanding in absentia orders that are just floating around in our society. And every now and then they get swooped up. And sometimes you'll hear heart-wrenching stories on the news about so-and-so with a wife and kids, or husband and kids, is just being sent out of the country in moments. And the answer is, they have an outstanding removal order. They didn't show up in court one day, or there was a final order, they had the hearing and they weren't taken into custody. And so finally somebody caught up with them, and now they're putting them on the plane. But the question about who gets counsel is another interesting question, because I can't remember, I think the statistic is pretty low. It's like 40% or something like that, 42%, but it's largely in detained settings. Most of the time in non-detained settings, and when I was in Philadelphia court is a non-detained court, I could probably count on one hand the number of pro se cases I did to a full merits hearing. I'm by hook or crook, I would continue cases, getting people lawyers, you have time to get a lawyer, because in immigration court, you have the right to have a lawyer, but they call it the privilege, but it's really a right, at no expense to the government. So people scrape together money, or there are nonprofits that actually take on cases. And between the nonprofits and sometimes law schools and scraping together money, I have very few so are there questions?
Any Zoom questions?
Any Zoom questions? Because I don't have that in front of me. So.
There's one being formulated.
Formulated. Want me to fill the silence?
I'll fill the silence.
Okay, go ahead, Jill.
So what do you think about, in addition to structural reform, how could we reform the substantive law to help this situation? So like, how could immigration law change to help ease the backlog, or to put less pressure on the immigration court? Like if you had a magic wand and you could change the removal grounds, or you could change the cancellation rules.
What I mean, I would probably, what I would probably do would rewrite the aggravated felony statute to make far fewer cases aggravated felonies. That would take away certainly a lot of the detained problem. The solution to making the system run faster and not have such a backlog is not a solution that people necessarily want to hear. You could devise a system that said, we're going to give all authority on asylum matters to USCIS, with judges having only review powers, not de novo review, just review the work of asylum officers. And that would make the system move really fast. But I'm not sure I want that change. In fact, I don't want that change. Initially, there was some talk back in the 90s when they rewrote the asylum statute, well, the EAD and all of that. There was some talk about not allowing judges to hear asylum cases, or asylum cases on review from the asylum office. And I mean, I don't have a lot of faith in the vast bulk of what happens in asylum office. I think there's some very good officers, but I think the vast bulk, I don't think they have enough time to do the cases the right way. Anything else?
Joe Gordon has a question. He
Okay.
can just unmute himself, so you should be able to.
It's not up here. Do you have?
He didn't type it in, so I think he wants to speak. Let's just let him, I can ask.
Maybe you have to.
Oh, maybe. Let's see. It says ask.
Yes,
That's what you need to do.
that was what was required. The setup of my question is about DHS, about OPLA. The prosecutors, if you will, in these removal cases are in a crunch. Their agency has issued a vast number of notices to appear. They have limited staff and time. Their frontline folks have responsibility for either all the cases being heard in front of a particular judge in a particular day, or just a vast number of cases in general. They seldom have the time to properly review files and then go digging, doing further legal review unless it's an exceptional case. They seldom have time to meet and confer ahead of time, as would be desirable. You pointed out that increasing judicial review would help, but wouldn't solve these structural problems. Any thoughts about what could be done aside from the broad-based structural reform that would change how many cases there are in removal?
Well, I think this doesn't necessarily go to a change in the law, but it goes to something that I've thought about, which is something on the much higher level. Attorney General and Secretary of Homeland Security have to sit down and talk about how much they want enforcement and how much enforcement can the courts handle. So I think one of the problems that you've raised, Mr. Gordon, is that there's inadequate staffing because in the prosecutor's office, the Office of the Principal Legal Advisor, or also commonly known as OPLA, those are the prosecutors of the Department of Homeland Security. They don't have enough time because of to prepare their cases, to deal with the cases in the way that you would hope that they would. So they are under resourced. I mean, they're doing their own photocopying. I've heard some horror stories in terms of just inadequate staffing. As the caseload continues to grow, because they keep issuing new notices to appear, the system can't, more is being added than is being taken away. It's backlog just grows. And I think there needs to be some very serious discussions at much higher levels, as they like to say in Washington, above my pay grade, about the policy of Homeland Security in terms of who they are picking up and putting into court proceedings and how many people they should. And I know we have now, after the Supreme Court ruled in June that Secretary Mayorkas can use prosecutorial discretion authority, although why the Supreme Court granted an injunction on that is beyond me, but they did rule ultimately the right way. The bottom line is that addresses the prosecutor once the case is in front of him or her, or in front of the office. Could there be a deeper question about how many people do they even want to go out and ferret out and charge? And that needs to happen, I believe, at some of the higher levels of government, because clearly the court system as it's now structured is incapable of it. So,
Well, thank you. I think we've run out of time.
does we
Oh,
get more credit?
Was there another question? Okay, so, thank you so much to Judge Morley for joining us, and please join me in thanking him for coming.